Hello, this is Matthew Chan and Oscar Michelin, and we're coming to you with a very special update. It's Christmas Eve. Can you believe this, Oscar? We're doing this video on Christmas Eve. What's wrong with us?
Christmas Eve, and I don't know, but I guess we're really into this. But the other thing is that it's the same temperature where you are in Georgia as where I am in New York, so that's a little weird too.
It is very, very strange. Well, I do know that one of the reasons why I wanted to do this was I wanted to give a special Christmas gift to our ELI community. I thought the timing was appropriate. And in this special episode, we're only going to talk about positive things. So what do you think about that, okay, Oscar? So
that's it, the power of positive thinking.
Great.
That's it.
Right. All right. Well,
nothing negative.
Right. Great. The topmost topic I wanted this update to cover is the AdverNet case. And I have been waiting patiently for you, Oscar, to expand on the little teaser that you provided to us a couple weeks ago. You sent me an email basically with a document, the Getty versus AdverNet case, that the defendant was one of your clients at one stage, right?
Right. Very, very early on in our Getty campaign, if you will, one of the first people that had contacted us was AdverNet.
Okay.
And I wish that I knew then what I know now about Getty, but we gave him some advice. We tried to resolve the claim with Getty, and then when they filed the lawsuit, we had to be relieved as attorneys because it just wasn't financially possible for this small company to sustain the litigation against Getty. Now, I'm not telling any tales out of school. It's all public information that's available from Pacer, which is the site that you can get federal court documents from.
Yeah, I love Pacer.
So I will obviously not reveal any client confidences. All I will discuss is what's stated in the public record and the decisions.
Very good.
And including is the fact in the public record that I moved, to be relieved as counsel, so I can talk about that.
Yes,
but
I saw that.
Right, it's a public record. So what happened was after we left, the parties, I guess, continued to litigate the issue, and the company, the defendant, decided or could not appear or did not appear for certain conferences, and the court entered a default judgment against it. In other words, a default is when the other side wins by default.
Right, because they don't show up.
The other side, right, didn't show up, didn't put an answer in, or sometimes if you don't comply with discovery, you can be held to be in default. There's various different ways.
Mm-hmm.
So then the judge did what most federal judges do. This is Judge Kenneth Fox of the Southern District here in New York. He ordered a hearing to assess damages.
Mm-hmm.
And, at that point, Getty was by itself with their counsel, and they presented certain evidence to try to explain their claim and the case to the court. And what the decision shows is that the court was less than impressed.
Oh my gosh!
The evidence presented.
They tore him up. I'm actually very surprised to the degree of questioning. It was pretty intense. Very specific questions, and the guy seemed to be squirming from what I could tell. But go ahead. Sorry.
Yeah, I mean, it's absolutely right. No, it's a good point because you very rarely see this in default judgment cases.
Oh. Yeah.
Normally, the judge just sits there, doing the crossword puzzle while the plaintiff or the defendant puts in their evidence, and then says, "Okay, that sounds about right," and moves on because, the feeling kind of is, well, it's an adversarial proceeding. The other side decided not to come in.
There you go.
So be it. But courts, courts are required, to make sure that manifest justice is done. And they have their equity powers to say, hey, just because someone defaulted doesn't mean you can come here without the appropriate proof. You still need to prove certain things.
That's amazing.
They felt that Getty had a problem proving the ownership and the registration of the licenses for the images that were involved, and as well as the kind of chain of custody, if you will, over the images between the photographer and Getty. And the court found that some of the things that Getty said in its complaint, that it was the exclusive user, the exclusive licensee, were wrong and was unproven.
And they also couldn't prove, with some of the images, if I remember correctly, when the infringement occurred. They couldn't nail down a particular date. And that was also an issue.
That was an issue because one of the things that we did put in our answer was a statute of limitations defense.
Very good.
You have 3 years to commence a copyright infringement claim.
Right.
So the question is always asked is, when does the infringement begin? And normally case law says it's when a defendant discovers the infringement, or could have by reasonable inspection discovered the infringement. And so there were a lot of issues there, and they felt that Getty had not proven when the infringement actually occurred. In other words, when did the images end up on the client's website?
Yeah.
And then when did Getty find out about it? And so that since they couldn't prove that it was within 3 years, that those cases were dismissed. So the decision, which I really encourage everybody, every single person who gets a Getty letter, to read and to try to understand just what your position should be should you find yourself being hauled into court. Now, as the complaint shows, in Avernet, there were like 30-something images. I think it was 37 or more images. So it was a major, major case for Getty.
And apparently they felt fairly confident. Otherwise, they wouldn't have filed. Or is it just because it was so large? What do you think? Why do you think they filed?
It was early on in the program. I think they probably wanted to try to push and have some test cases. The 5 or 6 lawsuits that they've started over this whole program since 2005 all occurred within kind of a couple of months of each other, more or less, within like 8 or 10 months. And all involved multiple images. So I think it was the sheer volume of the images that were involved that probably led Getty to say, yeah, this is a good one to bring to court.
Now, let me ask you something. In one of the things that I read, there was a section that said something about the agreements not being executed. Now, apparently the judge thought it was important. I was hoping maybe you could elaborate the importance of having an agreement executed. Can you explain what that means and why it's important?
Getty has these form agreements with the photographers who retain Getty, essentially, to be the exclusive licensee of their images. Without those agreements, Getty has no right to pursue these infringements because only the copyright owner has the legal right to bring an infringement proceeding over the infringement of their copyrighted works.
And the Righthaven cases definitely sent that message home to everybody.
Exactly right. And there's a big connection here between Avernet and Righthaven in the sense that it shows the value of kind of contesting and pushing back a little bit and making sure that the other side does have the proof required. I mean, one of the big problems with this Getty issue that you see all the time from, I'm going to say hundreds and hundreds of posts on our forum say, hey, I asked Getty to show me the proof.
Yes.
That they own the image, that they had an agreement with the photographer, that they had, a registered image, and Getty refuses to provide that.
They won't do it.
Right.
And the interesting thing is, this is why a lot of people who don't get educated have a real tough time. Because in Getty, when you ask, they said, no, we're not going to provide that. We will provide that if and when we file suit, and it'll come out during the discovery process. I mean, that's been their staple answer. They will bring it out when it's necessary, I guess, for them.
Right. And that's one of the biggest issues that I have over the whole program, because that's like, I'm in a car accident with you, Matt, and let's say the accident's 100% my fault. I hit you in the rear. You're stopped at a red light, and I'm texting, and I slam into the back of your car. But luckily, I hit the brakes just enough so that the damage is just a minor dent. And then you say to me, okay, it's $1,500 in damages. And I say to you, well, show me an estimate. You say, well, I have an estimate, but I'm only going to show you if you make me come to court. So why would I pay that? I mean, how can I possibly negotiate against that? It's unfair to say, I have this proof of my claim, but I'm not going to show it to you unless you make me, come into litigation. I think it's incumbent on the person who's trying to establish the claim to show a little bit of the basic proof. I don't need to see all your evidence, but when you're asking for such a large sum of money for such a minor infringement, I think at the very least you should be able to show the proof that you have the right to claim it.
Well, I certainly agree.
And they refuse.
Yeah, they absolutely refuse.
And look what happened with Righthaven. Because they didn't have the ownership of the articles, they only had this agreement to be the party that was allowed to sue, and that was insufficient. All their cases were dismissed. Their website's been shut down. All their claims, the millions of dollars they were anticipated, receiving from this program, out the window. Huge judgments coming in against them.
And now they're going after them personally now. It's closing in on the personal. They're trying to drag the people in personally to find out, hey, where's the money? You're going to have to sign off on this. I mean, it's gotten really, really tough.
Yeah, where did this money go to? You made all this money before somebody finally pushed back. So here in Advernet, I think the judge said, well, you only have the right to do this if someone has transferred or assigned that right to you, and if your agreements are unsigned, then what can we do? That may not be a valid agreement. Obviously, for a contract to be in effect, it has to be signed by the parties who are giving away those rights. So I think the court said that's just not good enough. I don't care about your standard contract. Where's the signature from the photographer? And again, you know what it's similar to? I mean, you've heard about all these mortgage fraud cases where banks were using, robo-signers.
Yes.
And had people in some, warehouse in Louisiana saying they were vice presidents of the banks in New York, L.A., Florida, Texas. Yeah. And they weren't any such thing. So, again, somebody got sued who had the time. In the mortgage cases, it was actually a retired lawyer up in Vermont. Oh, yeah. It was a retired lawyer. Yes. Yeah. Who decided, let me put the bank to its proof. And he salvaged his client's house and then spread the word when he realized that a large majority of the signatures on those mortgage documents were fraudulent. So, he brought the industry to its knees, really. It did. It brought it to its knees. Almost brought the country to its knees, but it brought the industry to its knees for sure. Amazing. Yeah. And again, who would think, right? Who would think these most basic issues? But I think good litigating, the idea of dotting all the I's, and frankly, while it was a default judgment, that's why the judge got involved, I think, because these are things that go to establishing the basic claim. I don't know that Judge Fox really thought how deep he was going to get into it. He probably felt he was just asking some very basic questions, right? Yes. Okay, so here's a simple question. So just show me, Getty, why you have standing. How come you're here, not the photographer? Oh, Judge, we have these agreements. Oh, well, they're not signed. Do you have anything else? Okay. And the next question. So how do you know that these images ended up on these websites within the last 3 years for the statute of limitations? Again, basic, very basic, not high esoteric issues, right? These are like the preliminary stages. Did you bring the lawsuit timely? And do you have a right to bring this lawsuit? Oscar, one thing
Oh, sorry. Did I didn't mean to interrupt your thought.
Yeah.
I thought really peculiar. I've read several documents from the Pacer. I have a Pacer subscription myself, and every once in a while I'll look up something. But maybe it's just my inexperience, but why is it in this particular case there was so much actual testimony being reprinted? Is that actually typical? I mean, it was very surprising to be able to read verbatim what the Getty Image employee said. I mean, regarding the whole process and how they get the images, and they talked about the Internet Archive. I mean, they really got into a lot of good stuff. Why was that testimony in there?
There's a couple of reasons. First of all, on a default judgment, you don't have the other side to tell you what they think was said. So the judge is going to need to review the testimony and the transcript. He can't rely on lawyer for Avernet saying, Judge, this happened, and Getty saying this happened, and then only go to the transcript to look at that. He's going to have to remember what was said. Secondly, Getty thought the judge overlooked certain facts and made a motion to renew the denial of damages. So that transcript, I believe, was part of an exhibit for Getty's motion to renew, to say to the court, here's the testimony, here's what you overlooked. And that's one of the main reasons why I think that was available. But, yeah, I mean, did you see that they used the Wayback Machine, archives.org.
It was actually surprising. I mean, I guess they were forced to admit, and by virtue of the Pacer system, it's made to the public of how, at least back then, how they did things. Now, they may have modified, tweaked their operation since then. But back then,
but I think it's generally, I think it's pretty much the same. I think the main thing they did that was different was buy PickScout for $20 million back in April, so that they eliminated the middleman. But, while we're on this topic, I think it's important that everybody realizes you can get a Pacer account for free, okay? Mm-hmm. And all you do is pay 8 cents a page.
But it adds up fast, let me tell you.
It could add up fast.
I've run up my account pretty bad.
Yeah.
Or if you're getting the wrong documents, you're stumbling around looking for. Yeah, you see something, it's like, oh God, this is worthless. So there's been a lot of times, but it is a great resource.
A little tip on that. Well, it's off topic, but sometimes on the right, you can click the entry which describes the document a little bit more. Mm-hmm. And it increases your chances of getting the exact document that you want. But in any event, court decisions are free. They don't charge.
Really?
So you can review court decisions for free.
That's good to know.
And also, once you pay the one time, you're free to download it and save it, so that you don't have to pay it if you want it again.
I gotcha.
But everyone and a Pacer is a national account. So
yes,
I can log in to any federal court around the country and use my same Pacer account and look at court documents. And it's a tremendous, tremendous resource, not just for lawyers, but for litigants and for folks who are interested in this type of an issue. And it's well worth doing because this was really an eye-opener and gave a lot of evidence into how Getty Images operates, or as you said, operated its litigation program. So it was, I think, a big win for the little guy. I feel confident that Getty did not expect to walk out of there without $1 and to have gotten kind of lambasted by a federal judge in the process. And, I think it gives a lot of entry for people to see how these cases get litigated, what claims you can raise on your own behalf. And as we said before, it's a very good comparison to other copyright troll cases like Righthaven, and shows the value of pushing back a little bit and making sure that they have the proof of their basic claim.
Well, Oscar, what I do want to say is I give you a lot of credit for putting the idea in my head about 3.5 years ago when we met, that the court system, the judicial system, is fundamentally fair. I mean, there's no question that there's pockets of corruption and, bias and things like that. But but you have always told me, and it's always stuck with me, that when you're dealing with such matters, that they're generally going to be fair. And so for me, I've always taken great peace in knowing that, even though I'm not a lawyer, I haven't studied, I could never be as smart as you, that if my intent and what I did was sound, I sort of take comfort in knowing that the judges aren't going to let this thing go off the ditch. Does that make sense? Even if you are ignorant. There is a sense of fairness. And AdverNet, this case is, with 37 alleged infringements, and the defendant doesn't show up, there is no better example that I can think of fairness. It's crazy.
Right. I don't know many.
Call of Duty, if you ask me.
Yeah, it really shows the value of having this inherent requirement in the court system that, some fundamental fairness has to apply, and that just because you want a default doesn't mean you still don't have to show some of the most basic elements of your claim. Again, it was also, I think, to AdverNet's advantage that they had an attorney draft an answer that had these affirmative defenses that
absolutely
the court mentioned in the decision. So it wasn't a complete default. It wasn't like they didn't answer.
Right. They had something to work with.
They just failed to appear.
Right.
But the answer was filed at a time they were represented, so that's part of the record. So the court could look at the answer and say, well, they raised these affirmative defenses, and therefore we have a potential issue to clear up. So, by and large, certainly courts end up getting it right. But at the same time, it's always better to have someone, taking your side, speaking only for yourself, and having your interests,
Okay, I have a question.
First time, if you look,
you have mentioned a couple times to me that you wish you had stuck it out. Now, obviously, the client chose not to utilize your services, and at the time you couldn't have known what could have happened. But had you why do you say that you wish you had stuck it out? Do you think what would have been materially different if you had stayed involved with this to the very end? Could you have gotten legal fees, or that's the thing, or from Getty, from what they were doing?
I don't think I could have. No, I could not have gotten legal fees. No, I would have stuck it out, because at that time I had no idea how big this Getty letter program was going to grow, how important it would be to Getty's business model, how many hundreds, if not thousands, of letters per week they were going to be sending out, how this would become something that would affect thousands and thousands of people.
You didn't realize it was going to be such precedent setting, I guess.
Yeah, that it could be a very, very important legal case. Mm-hmm. And, had I been there representing AdverNet, we could have exposed other things perhaps and had a better, even a better decision come out that would have been maybe legally binding for other issues as well.
Like?
What's that?
Well, like what? What could have been better?
Well, I don't know. I didn't get to examine their agreements. I didn't get to examine the methods of how they uncovered the images, of how they, used the dates, how they could prove that screenshot was taken on that date. Different types of proof issues that we could have potentially raised and litigated. And I think also trying to get the feel from the court of how it generally felt about these claims. The value, is it worth litigating? How much money would these images be worth? There could have been many other things. That would have been great. Could have just tried to get a feel for how the court felt about these arguments. But more importantly, the best thing about it would have been putting Getty to its proof and saying, okay, let's see where it goes.
Now, would you have done this? I'm sorry. Would you have done this during the discovery process or the cross-examination? Because if you do this on the cross-examination... Oh, go ahead.
No, see, that's the whole thing. If we had stayed on the case,
Yeah.
we could have served Getty with interrogatories, discovery demands,
Right.
document production, to really get into and look at their business model.
I see.
And how they generated this claim amount. Why are you claiming this number? How do you generate your license fees? How often, for example, do you actually get $1,000 for a picture of a cactus? When's the last time anyone paid you, $1,250? That's $1,250 for a picture of two men shaking hands. In a low resolution thumbnail. So I mean, there are a lot of things that we could have, put them to their proof. But understand, that would be a tremendous time requirement because.
Oh yes.
Getty would respond in massive thousands and thousands and thousands of documents.
Basically drown you in paperwork, potentially.
Right. And I think it's also interesting that Getty's never sued that I know of. I'm not even sure they've ever issued a claim letter to a big, deep-pocket defendant. And I find it hard to believe that only small companies are involved in these issues. I would have liked to have seen whether Getty ever sent one of these letters to a Fortune 500 company, to somebody who could invest the money and fight back a little bit. Or was Getty specifically just targeting smaller companies?
Well, I think we've talked about this before, and we've seen this in the Righthaven cases, that when the company is large enough, they tend to view it as a nuisance, and even though they could afford to fight it, they got better things to fight. They'd rather just give up the few $1,000s, just go away and be done with it.
It would either have to be a significantly large claim,
yes,
or go after an image that was central to their business.
Yes, but we've already seen that in the Righthaven. And even as heavy-handed as Righthaven, and I have to tell you, between Getty and Righthaven, I think you and I agree that Getty still by far is the more respectable one.
It's not even close. No.
I know. So
Getty is a well-known company, and Righthaven, the thing was a scam from the beginning.
Right. Well, Oscar, do you have any other comments, parting comments regarding Avernet that might be useful?
No.
Okay.
No, I just think that it'd be interesting to see whether in future litigation, other folks, in cases involving master file, other digital image cases, can use Avernet to try and establish some precedents. But we're going to have to wait and see if these cases end up coming back into the courtroom anytime soon.
Well, that's the deal. I mean, the looking for a lawsuit is actually fairly rare. So until they pull that lawsuit trigger, you really can't bring up the Avernet thing. Or at least you could, but I don't know. But anyway, closely, we've been sort of touching on Righthaven, so I wanted to get a few comments from you regarding the latest fiasco. The domain has been taken away from them and the website.
Right.
I mean, this is pretty bad when you're going after the website versus any other assets. I mean, does Righthaven not have furniture or what to go after?
No, I guess not. I mean,
there's no bank account.
I envision somebody standing naked in a barrel. I don't know if you remember those old cliches.
I do remember those.
It had like a wine barrel with some suspenders on them, and that's kind of like where Mr. Righthaven is right now. But
Mr. Steve Gibson and his wife, I guess. It's embarrassing. It is really embarrassing. Why is it that they're not declaring bankruptcy, or at least the LLC? Is there something that I'm not getting? Why are they fighting this to the bitter end? And why is Sean
bankruptcy?
I'm sorry, the attorney Sean Regano or something like that. I mean, he's still fighting for them. I don't get this at all.
It costs money to file bankruptcy, particularly a commercial bankruptcy, and it might be cheaper just sometimes to just fold the tent up and
I gotcha.
Go away. You only declare bankruptcy when you're trying to protect the company and hope for it to either move forward or liquidate, right? If you have nothing to liquidate or you don't want to reorganize, those are the two basic things that bankruptcy allows you to do, either liquidate or reorganize. And if you want to do neither, then just let them have claims against you and let the sheriff come and take whatever property they could find. So the only thing they really own of value anymore is the website. And also, of course, taking the website stops the trolling. That's the real purpose of taking the website. It's not to own the website. It's to stop the whole program from continuing.
Well, it's all I can say is it's quite embarrassing.
Oh, yeah. Well, I tell this to my law students.
Mm-hmm.
That's part of the thing about litigation, and is that you do it publicly most of the time. So when you win, it gets published, and when you lose, it gets published.
Oh, gosh.
When you win a big, it gets published, and when you lose big, it gets published. So, it's all out there, and many times you'll see decisions where they'll even talk about the lawyer didn't do this, or the lawyer could have done that, or, So it's a public arena. So Righthaven stepped into it. They made a lot of noise when it first started, and, I think it's only fitting that their, death should be reported in the media as well. It's doing a good job of keeping up. What's that? Did you want to say something?
Well, I wanted to ask you. I'm asking you. I'm sort of putting you on the spot on a lot of these questions I've never been able to ask you before. Now that you've been watching this, what's your opinion of Mark Randazza? I hope I didn't mess up his last name. The attorney. I mean, this guy. Oh my God, he is relentless. He is thinking all the angles. The marshals going after the domain. I mean, I have never seen anything like this. This guy is just fighting. Yeah. What do you think about this?
Before Righthaven ever came to the forefront, I had followed Mark's blog and known him to be a tremendous, First Amendment and federal litigator. And they picked on the wrong dude. I mean, this guy, I can't remember who his client is, but he's no slouch, and he knows how to litigate, and he has a passion for the issue, and that combination.
I can't think that's very helpful when you have when you're passionate about the issue.
Forget it. That beats almost anything else. If you can get your lawyer to be passionate about your particular issue and to take it on as his or her own, feeling as well, it certainly incites them. It excites them, and they want to do right by you. Of course.
Well, I'm starting to think. I mean, I cannot say. I mean, this is just an outsider looking in, but it's getting a little. It looks a little personal. I think Mark really wants to put the Gibsons out of business, and he wants to put a stomping on Sean Mangano or whatever the last guy's name. I mean, he's really going after them very hard. This does not seem to be just a professional dispute. You get what I'm saying? That's traditionally the case, but between lawyers. I mean, he's got it in for those guys.
I think he's
for whatever reason,
zealously, and I think he's doing it all the way down to the nth degree. I mean, we've had cases involved where we try to collect judgments for certain clients. We'll take the watch right off the guy's wrist. We had a case, as a matter of fact, where a guy owed a substantial amount of money to our client, and he showed up at his deposition wearing a Rolex.
Oh, no.
And, and I said, well, that's a nice watch. Is that your watch? He said, yes, it is. I said, you own that Rolex, right? He said, yes. So here's the best part. His lawyer said, or must have advised him, because he said, yeah, but I looked up the CPLR, and I'm allowed to keep a watch. And I said, right, but you didn't read all of it. It says one watch not exceeding $35 in value.
Oh, no. That was the caveat. It cannot be a watch that's worth more than $35?
Right. So the next day, we filed a motion in court requiring him to turn over the Rolex.
That's amazing.
And, well, my client got his Rolex.
Okay. That's a great story.
You've got to pursue, it's for your client's own benefit. And I think Mr. Randazza sees that this not only benefits his client, but all similarly situated people as well. He knows the pervasiveness of this program, and shutting the website down, is like cutting the head off, right? That should end it.
Yeah. Well, one thing I'm going to say to our credit on ELI is that a lot of these stock photo companies and all that, they try to segregate the issues and say, hey, look, they try to take the fight one-on-one. And you and I have been very creative in, bringing in other cases and discussing it and see how it's all tied in. And I think it's very important we continue to do that because, they have their perspective and they know how to position it where it's going to make them look good and stronger. Well, if you're in a defense position, at least from my perspective, one of the things is you change the rules of the game. We're not going to play by your terms. So anyway.
You want to try to, it's always good to also have judges see the bigger picture. Maybe it's not just about this case.
Yes.
But, on that note, we should really commend our partner, Budapai, for constantly updating Eli about Righthaven. And he sat on that information and kept updating and hounding it down and keeping it, in the forefront. So I got to give a big shout out to him for staying on top of that. And I got most of my information about Righthaven from our Facebook page, from his postings and his information there. So it's a big credit to him.
Yeah. Well, speaking of Budapai, let's do a quick shout out to everyone during this holiday season. Eli is a team of 4. And obviously everyone knows about Oscar and myself, and I think the majority of the people know about Robert Krosankis, otherwise known as Budapai. And most recently, we've had Jerry Witt, who goes by MC Films, join the team. And so I'm hoping to do an interview with him sometime soon, probably early in the new year. So a quick shout out to the new members. Thank you for helping us out. Oscar and I appreciate it very much.
Absolutely. They're strength in numbers, and now we're up to 4. And I got to tell you,
and a lot of eyes. Lots of eyes reading and lots of minds thinking. So
that's right.
All towards a common cause, which is always a good thing. Now, one thing that you pointed out is, Oscar, about that we're slowly evolving to become, I guess, a copyright trolling site, reporting on that. We started with the Getty images, and this thing has just sort of branched off into God knows where. I mean...
Right. I mean, let's not forget that it was also through our site, in a large way, that we put an end to the image line issue and George Riddick. We forgot that battle, which was our first non-digital image battle. And now we have Righthaven. So there's other things that come on. The website has a lot of value because it gives people a place to come and talk about their issues and see that there's others who are similarly situated and how they've resolved it.
I tell you, a lot of our community members also plant nuggets of ideas. I mean, they brought in Righthaven. They brought up, hey, did you know about this is going on? And most of the time I would read it and it's like, nope, I don't know what's going on out there. Right. Because I'm focused on the Eli community. I don't go poking around outside until someone brings it to our attention. And of course, once they bring it to our attention, it's, it gets pretty interesting fairly quickly. So. Well,
particularly when you consider that there's always a lot happening on the digital image forefront. We don't need to look out for more information. There's always new things that are happening on the area that we are focused on primarily.
Yeah. Okay. Well, as we wind down this recording, I've got a couple of other more quick announcements. I'm happy to say that Oscar and I, in terms of Eli anyway, we have agreed to renew our vows for 2012. Oscar, you and I are in it for, I guess, another year. And the only reason I bring this up to the Eli audience is that I've always been on the fence. I mean, every year, or maybe 2 or 3 times a year, I go on this rant about how I'm on the fence, and I'm always telling how Oscar keeps me motivated and keeps me in it. And this year is no different. I told Oscar, I said, look, it's a nice 3.5-year run, and I got to make some changes. This thing is just, it's growing so much. Remember that PowerPoint presentation I showed you? I mean, unless you really paid attention to it, it's really grown quite a bit. I mean, there's a lot to manage. And I said to Oscar, I cannot put in any more time. I got to shut something down. Something's got to change. And I just want to let everybody know that Oscar stepped up, and has agreed to help support Eli in a grander way. And Oscar, would you like to chime in on that?
No, I mean, I think the site's important. I think the discussion it presents is unique. You would think by now someone else would have picked up the cudgels. I think you and I kind of maybe hoping somebody else would come along and start, do some of the heavy lifting. But we're glad, even though we're not the owners of the site, and you are, Matt, but to support you in any way that we can to keep it running. And I think, it's important that people realize the amount of work that you specifically put in.
Oh, that's crazy.
Keeping it fresh, keeping it updated, making sure people aren't posting things on the forum that are obnoxious and lowbrow. We're getting hundreds and hundreds of unique visitors a month, right?
Yeah, we're up to, I think we're going to close in on 1,000 very soon. 1,000 unique visitors a day. I mean, it's crazy. Yeah.
Not a day.
No, we are getting close to that.
Are you kidding me? I didn't realize that. That's fantastic.
No, it's gone quite a bit. Hang on a minute. Let me verify this here. Our high statistics came from November, and it's sort of it's actually a little crazy. Even I'm surprised by the numbers, really. Let's see here. I have this little cheat sheet that I look at.
Well, while you're looking that up, I just wanted to finish up by saying that's why it was great that we have two more folks helping us out, helping Matt out. And, when we saw that while there were certain donations coming in through the PayPal account, it wasn't enough to pay for the service space, for the time.
Yeah, my time especially. Holy cow!
Right, and the the bells and whistles that are on there, all the various, design elements, the social media connections, the Facebook page, Twitter. I mean, it just keeps growing. So
yes, it does, like little tentacles.
I think it's going to keep going. I think 2012 is going to be fantastic. I think the site's going to grow because this issue isn't going away, and as we can see, other companies are mimicking it and mirroring it, so that there's always lots to talk about. And I think people need a place to go where they can get information in one place and talk to others. So. Right. Glad we could do it. Let's keep it going, and looking forward to a great 2012.
Well, great. Well, thank you so much, Oscar. I'm happy to.
Wait.
What? Oh, I'm sorry. The number. Well, the number that I have on the website, based on the latest information from November, is that we get 11,700 unique visitors per month. That's been the peak. So we're getting ready to hit 12,000 unique visitors per month. We are closing. We are going to, within a couple of months, probably hit 400 Facebook page members that are reading our updates. So I got to tell you, I wish I was doing all the work, but really they're pumping out letters like crazy.
Yeah.
And so we're trying to accommodate the traffic, and that's what we're doing.
Well, look forward to another great year, Matt.
Okay. All right. Well, thank you, everyone, for joining Oscar and I on this very special update of the ELI update series. And we will see you in the next new year. And we've got additional announcements we're going to make. But for now, the big deal is ELI will continue with Oscar and I working together into 2012. And I, for one, am quite happy for it. What can I say? He stepped up, and that's all I can do is just be grateful during this holiday season. So everybody, Merry Christmas, Happy New Year, and a Happy New Year and Merry Christmas to you too, Oscar.
Likewise, Matt. Be well.
All right. Take care.